your refreshments, but I wanted to go ahead and start with some of the questions. We have quite a few. I'd like to get through several of them. If there's still questions out there, if you'll raise your hand, and one of the question fetchers will bring them to you. So let me know. Raise your hand if you still need to have your questions picked up.
I'm ready.
All right, here we go.
Fire away.
We'll start with a couple fundamental ones.
Okay.
What was the specific provision of the Constitution that was found to be violated by the Voting Rights Act?
That is a great question. There really was.
I've been asked to repeat it.
Yes.
What was the specific provision of the Constitution that the claim was that the Voting Rights Act was in violation of?
Well, there wasn't really a specific provision. There was just this sense that the mechanism established by the preclearance process is a mechanism that runs counter to our notions of how the federal system ought to operate. So it was a fundamental sense that that mechanism disrupted the appropriate federalism balance between states and the national government. And I will say, I think that's a fair question, and there really is no, honestly, there wasn't a specific provision that was identified as having been violated by this preclearance process. That being said, I think even the strong proponents for Section 4 and Section 5 in the preclearance process describe that process as exceptional. And so I guess in some sense that means that it's a highly irregular mechanism that we should rarely sort of have in this current structure, in our governmental structure. But all that being said, the reality is there was no specific provision in that this violates Article blank, Section blank of the Constitution. That's not a part of what gets laid out in the majority opinion.
That doesn't have to be the case in striking something down as unconstitutional?
Apparently not, no.
One bail out and one bail in question.
Okay.
With the Section 5 being a bailout method, was there a way to be put back in, or was it a permanent bailout?
Oh, no state had ever, it's a good question. We'd not really even gotten to the position where we had bailed out entities that had been bailed out long enough to be bad enough to get bailed back in. So it's not even, we don't know the answer. It never emerged as an issue. It's a great question. But not that many jurisdictions have bailed out. Typically it's been political subdivisions and not states that have bailed out. And as I say, even for those bailed out entities, none of them have been bailed out very long. And there's been no developments that raise questions about whether they've been bad behaviors who for some reason ought to be brought back into the preclearance process. Good question, but it just never emerged as an issue.
And with the bail in that
Yes.
you're describing at the end, what kind of activity would you imagine does Holder have in mind when he's thinking about putting someone back in the pod?
It would be, my guess is that he would say, and he will say to the court with regard to Texas, Texas has been engaged in a variety of practices aimed at intentionally undercutting minority voting rights in that state. And because they have engaged in a pattern of this intentional behavior, they should be, I think this is what Eric's going to ask for, they should be subject to Section 5. He's going to ask the court through Section 3 to make them subject to the process that is statutorily embodied in Section 5. Because remember, Section 5 is not unconstitutional. Section 4 is. And so that process sits there, ineffective because there's nobody subject to it. I think what the Attorney General is going to do is to try to use Section 3 as a way to make them subject to Section 5. Now, Section 3 doesn't say if you bail in, you bail into Section 5. It says you bail in to some process that the court could subject you to. The easy thing for a court to do if it determines that a state should be bailed in, the easiest thing for the court to do is to bail them into the already existing procedure, which is the preclearance process in Section 5. I think that's what he's going to ask for.
And just to kind of make it
Yeah.
more concrete for us, what would be a specific practice that would get a state in trouble?
Oh,
What's the most common violation, maybe?
Well, the most recent, what Holder's hanging his hat on is a recent determination that the voter ID law in Texas was adopted with the purpose of cutting into minority voting power. That's why they did it, not that they wanted to do this thing and it had this effect. The Texas context, and I'm not in Texas, so I don't know the context, but the Texas context, at least as determined by the court that was reviewing the voter ID provision there, the 3-judge panel, the Texas context is not only is this retrogressive, you meant to undercut minority voting power when you adopted this thing. And so it's that kind of, I should say the Section 3 threshold is really high, right? Section 5, that the threshold for being covered generally is the application of the formula. And then you get subject to the Section 5 process. You don't even get involved in the process under Section 3 unless there's a determination not only that you have acted in ways that undercut minority voting rights, but that you've intentionally acted to do that. That's a hard thing to prove. It's a high standard to meet. Even if the Attorney General is successful in meeting that standard and subjecting Texas to some sort of preclearance as a result, I don't know how many other states are susceptible to that. So Section 3 is an alternative, but it's a distant second best to the kind of coverage that you get by application of Section 4 and Section 5. Does that make sense? I mean, it's a very high threshold. He thinks he can satisfy it with Texas. He's looking to determine whether he can satisfy it with practices in other states. The number of states that will be subject to preclearance through successful Section 3 actions will be a much smaller number of jurisdictions than the ones that are subject to the process before the court invalidated the process in Shelby County.
What's going on with the DOJ and these over 700 objections in more recent years? Are people behaving worse, or are they looking harder for smaller violations?
You know what? That's a good question as well. I think a number of things have happened. I think the analysis that takes place at DOJ is a lot more sophisticated than it used to be. These voting rights cases, these Section 5 cases, Section 2 cases as well, they're really data dependent. There's a heavy analysis of voter registration data, census data, because of what you're trying to identify when you look at a Section 5 proposal. If you're in the voting section at DOJ, you're trying to make some assessment of what the status quo is for minority voters ante, right? Before this proposal, what's the it's a weird thing to say, but it gets, I don't mean political Republican Democrat, but political in a sense that, you know, you're kind of saying, well, what's the political power for this group in the status quo ante? And how will that be affected if this change goes into effect? And if your sense through analyzing this data is that given the way the new lines are drawn, it's going to be harder for minorities to elect the candidate of their choice. It's going to be more difficult for minorities to participate fully. So their power, in a sense, is going to be reduced. I mean, that's the sort of rough sense that you're trying to identify when you look at these Section 5 proposals. DOJ is much more sophisticated than it was clearly in the early stages of this. Jurisdictions are more sophisticated too. I would just say I just think there's just more sophistication, and who knows? I don't know if you can make an assessment that that more objections means more than just more sophisticated review. I mean, does it mean that some jurisdictions have hit a step where they're looking for ways to undermine voting rights? I don't know, but it's hard to put my finger on why those numbers have changed. The point of the dissenters is this volume of objections demonstrates clearly that these professional group of folks at DOJ who look at this are continuing to find, in present day circumstances, legitimate reasons to reject these proposals. And I should say, I did work with because I did work with the Civil Rights Division when I was at DOJ, I did some work with the voting section, on some pre-clearance. Most interesting was that New York's covered, a part of New York's covered, and I still remember Rudy Giuliani was the mayor, and Rudy Giuliani wanted to make a change with regard to the election of school boards in New York City that touched on school boards in the covered portions of New York City. So he submitted his proposed change, and the voting section was about to object. They had a lot of concerns about it, and Rudy Giuliani wanted to have a personal meeting with Ms. Reno to sort of make his case. And so he came and he made his case, and I have to say, he was very impressive. He clearly knew the law and made his case, and I think ultimately they submitted a modified proposal that DOJ did clear. But the folks that do the bulk of the work in the voting section, they're career civil servants at DOJ, and they work hard, in my experience, to just apply the standards that they've been given to make the call that they're called upon to make.
And if the key measures in the Voting Rights Act were to be temporary,
Yeah.
In your mind or in your estimation, what should practices look like to where that temporary status is fulfilled, or doesn't need to be in place anymore?
I think that's a really good question. It's a question across a lot of fronts in the law right now, I think. It's this question of, you look back at the civil rights period and the period immediately thereafter, and where we have this clear national recognition that we've got serious problems with regard to civil rights. We enact as a country significant, meaningful legislation to deal with these issues. And in some cases, we adopt special provisions like Section 4 and 5 in the Voting Rights Act to deal with egregious situations that we hope we can repair in a temporary, through the use of tools over a temporary period. But I think we learn that these issues take longer to address fundamentally than we thought. But it still raises the question, I don't really have an answer. Is there some point where we have arrived, right? And we reach that stage where the temporary, extraordinary measures are no longer necessary, and we can sort of just pull those off and go back to a status quo that doesn't have those extraordinary devices in place. I think that's a real question for the Section 4, Section 5 conversation. It's a real question for affirmative action in higher education, right? Remember these cases, not the Fisher case, but Grutter and those cases decided a few years ago, where the court, and Justice O'Connor is the key swing opinion, she decides that it continues to be okay to take race as a factor in higher education admissions, but she says as she upholds the use of race for admissions going forward, there has to be some point in time where the need to do this fades away. And she didn't identify a time. I think she suggested a time. I think she suggested, 10, 15 years? I can't remember the number, but 25. She put a number out there and said, maybe when we get to that, does that mean that we've gotten to a point where we can roll back these special protections, if you want to call them that? And so we're at a period where I think it's a meaningful thing to have a conversation of when, if ever, we reach that enough is enough point when it comes to sort of special things that we've seen the need to put in place. Is that need going to go on forever? I don't know. I don't think the people who put these things in place hoped that that would be true. But we'll see. I don't have an answer to what it's going to look like, but it's a good question to raise when a statute that was enacted for 5 years has now, we found a need to continue it much beyond that period.
If I could group two questions together that...
No, you can't.
that deal with racial equality and voting more broadly in America. The first is, why do you believe that there must be a renewing of voting legislation for African Americans in the United States today? And then more pointed, do you think Holder is representative of a general indifference to racial equality, for example, when thinking about access to education, criminal law, or other issues?
Okay, let me take the first one. I think it's more than African American voters. I think it's minority voters. I think that the Voting Rights Act is as salient for Hispanic voters in many parts of the country as the Voting Rights Act is for African American voters in parts of the country as well. So for me, it's not. The question is there a continuing need to keep in place the use of special tools that ensure that voting rights are protected? And I actually think it's the salient question is much less what I think about that than whether that judgment should be allowed to stand when an overwhelming majority of the Congress thinks that's true. Right? This isn't Reggie Robinson's statute that he has decided to try to impose on the nation. This is the representatives of the United States deciding overwhelmingly in 2006, not that long ago, deciding overwhelmingly that the circumstances in the states that are covered by this legislation and subject to this special treatment have changed, but they haven't changed so much that the use of this special tool is no longer necessary. And when you have 98-0 votes in the Senate, overwhelming bipartisan majorities in the House supporting that proposition, for me the question is, why should that judgment made by our elected representatives be rejected? And so that's why that's my touchstone for determining that there's a continuing need. It's because the judgment has been made by our representatives, and it wasn't a frivolous judgment. It was a serious judgment based on a serious consideration of a voluminous and detailed record on the issue. Now, what's the other one about Holder? I didn't quite get that one. Is he?
Do you think Holder is representative of a general indifference to racial equality?
Indifference? The Attorney General? No, I don't. So I can just answer that one short. I don't. Yeah, I think Holder doesn't represent that at all.
Is he equally aggressive in thinking about, say, criminal law, sentencing guidelines, Voting Rights Act?
Oh yeah, I mean Holder. I think I should have disclaimer. I know Eric. I know him very well. When I worked at the Justice Department initially, when I first got there, he was a U.S. attorney. Actually, he was a U.S. attorney for the District of Columbia, and then ultimately became a Deputy Attorney General. And we worked closely on a number of anti-crime initiatives. The deputy is the sort of hard face of the Justice Department in the hierarchy. They deal with the crime issues. They manage the U.S. attorneys. They develop the criminal, the sort of crime posture as it relates to the federal government. It's the Deputy Attorney General that's really responsible for carving that. And Eric was, he was the Deputy Attorney General during a time where violent crime across the country was rampant. And he was a key part of the federal piece of the effort to bring that kind of violent crime under control. And voting rights, I think he's taken, I don't know that he could take a more aggressive posture. Section 4 and 5 have been validated. Let me see what Section 3 can do, right? I don't know what else he could do if you were looking for somebody to aggressively respond to the decision that's been made in Shelby County.
And do you think this discussion and invalidation of this court case represents a broader action to try to disenfranchise African Americans? Is this really a reassertion of racial inequality?
Boy, I hate those broad brush kinds of things. I don't know. It's the court made a decision that was not surprising given the views and the philosophies that you see reflected in the 5 justices that decided to hold Section 4 unconstitutional. Now I don't know whether the court decision, whether I would sort of label the court decision. A court decision is a sort of reaction to a case that gets put in front of them. But I don't have a clear sense of the jurisdictions that were actively engaged in seeking the repeal of Section 5. I'm a little less sanguine about what that represents. Because we have jurisdictions we have a number of states that have proposed voting changes over a number of years that have been found to be, have a negative impact on the rights of minority voters, and they want to get out from under that so they can go ahead and adopt those provisions anyway. So I have more concern when I think about the states that have been projecting and proposing changes that have been rejected and will now be free to make those proposals without regard to preclearance. That activity concerns me. The court decision as any sort of symbol for inequality, that's a bridge too far for me to go at this point.
If Congress is so overwhelming in its
Yes.
reauthorizations, why don't they fix the thing?
That's a good question too. We'll see, right? Right now, here's my take. I already talked about how I think there's some promise. I don't know that I'd bet the farm on something happening legislatively. I think there's some promise that something will happen. In addition to what I talked about before, Eric Cantor being, moved when he was in Selma and sort of, his interaction with John Lewis, and now he has a better appreciation for the value of Bloody Sunday and a better appreciation for the value of these voting rights provisions. I think that's all true. I take him at his word. I also think that there's a practical political reality for an ambitious, youngish Republican like Eric Cantor. Clearly, this is my sort of political hat, small p. Democrats, the constituencies most affected by this decision are constituencies that Democrats want to respond to, right? And so there's incentive for congressional Democrats to want to fix this, to want to respond to this decision. John Lewis will be the leader of that effort. You'll have lots of colleagues and allies on the Democratic side in both the Senate and the House. Republicans have, like Eric Cantor, youngish, ambitious, they have other motive here. They saw the demographic breakout of voter returns in November, and the demography that played such a powerful role in how the election turned out in 2012 is only going to magnify going forward. So if you're an ambitious, youngish Republican and you understand that demographic shift and those demographic ripples, and you understand that for many of those demographic constituencies, something like the Voting Rights Act being fully effective is important, you might have an incentive to at least be seen as wanting to be responsive on something like this. So that's why I think there's some practical hope beyond I was moved in Selma and that kind of thing. But on the other hand, Mary and I were talking about this during the break, even though the votes were overwhelming in 2006, they weren't under the radar, but they weren't front and center either, right? The legislative question of whether to extend for 25 years the special rules in the Voting Rights Act in 2006, that wasn't a spotlight issue. And so, yeah, I've looked at the record, it looks pretty good. Seems like there's a good rationale for continuing these special rules for 25 years. I'm going to vote for it. So you cast your vote, the numbers look great, and Voting Rights Act is continued for another 25 years. Now fast forward, we're now in 2013 or 2014. Section 4 and 5 have been invalidated, and now there's legislation proposed to repair what the court has identified. That is legislative activity that will have a, spotlight on it. And what that means is folks who voted for the extension in 2006, who were persuaded by it, they thought it made sense, but there was no pushback really. It was an easy vote. It looks like, the record looks good, this makes sense, I'm gonna vote for extension. Imagine that same member of Congress in 2013, this issue is now front and center. The proposal that gets submitted to deal with Shelby County is gonna get major media coverage if it's ever introduced. The process to consider that legislation is gonna get major media coverage if it is produced. During the course of that process, people that have all kinds of different views, adverse views with regard to Section 4 and 5 are going to make their voices heard and put really vocal and other pressure on members of Congress to oppose this. And so that same member of Congress who in 2006, when this issue wasn't so much in the spotlight, looks like a good case to me, I'm voting yes, no problem. That same legislator who comes from maybe a swing district or maybe a solidly Republican district, or name the kind of district that he or she might be from. There are people who are vocal there who say, wait a minute, why are you thinking about voting for that special civil rights provision that's been introduced to deal with the Shelby County case? There'll be a kind of pressure when this is under the spotlight that could have an effect on those big numbers we saw from 2006. So I think that's a part of the dynamic as well. And then finally, there's just the practicality of what should the fix look like, right? It's one thing to be John Lewis or Eric Cantor or anybody else and say, we need to respond to Shelby County, we need to come up with a formula that satisfies the concerns that the court raised in this case. Well, what does that look like, right? Once you make a decision that you want to respond, but then you got to figure out, well, what does the response look like? What does the new formula look like? And does this new formula, it has to be anchored in current reality, has to be anchored in current conditions. What does it look like? And will the court think that it satisfies the concerns they've raised? And there's also the interesting dynamic that if you picked If you developed a formula that truly reacts to current realities, there might be 15, 20 states covered, right? Who knows what it would look like? And so there's a practical problem of actually, the technical problem of actually saying, well, here's legislation that fixes the Shelby County problem, addresses the court's concerns. There's that, which I don't think anybody's done yet. I know they're talking about it and working on it. And then there's just the political problem of once you have that enactment process in a spotlight, what kind of pressures does that put on members, and then how do they react to those pressures?
So a last question.
Okay.
I'm going to let you give us a take-home message here.
Oh, no.
I am writing a new story on your speech.
Okay.
Could you please briefly and clearly state your position?
I thought I did. I mean, I favor I think Section 5 and Section 4 have worked, but then everybody thinks that, right? Even the opponents. And I don't think the changed circumstances are such that a congressional determination to continue those special rules in place ought to be abandoned. If anybody's taken a look, you can. If you look at the case, they cite the study that the Congress undertook to determine whether this legislation still made sense in 2006. It's, from my perspective, I'm pro-civil rights, so I have a bias. It's convincing a case. There are practices in the covered jurisdictions and proposals that emerge from those jurisdictions that you read some proposal that's dated 1999 or 2001, and you think, no, this has to be from the 50s or 60s. I mean, there are still those kinds of proposals emanating from those jurisdictions as recently as the last 5 or 6 years. And so I think there's a continuing need. I think the congressional record demonstrates that. And for me, that's the question, is did Congress study it thoroughly? Is there a justification for the determination that the Congress made? Are you persuaded by the judgment that the Congress made? I am. I think the Congress was thorough. I think its judgment was justified. And then you have overwhelming vote in favor. That, to me, that means this ought to continue for the period outlined in the renewal in 2006. Is that sort of, get it? Okay. Yes, Mike.
Somebody asked about Eric Holder and the criminal laws, conservative and liberal on that. One thing Eric Holder is doing that is actually extremely important is this. The right to counsel, there's a Sixth Amendment right to counsel, but basically it's in the hands of the states. The states have the basic control over how counsel is applied to indigent defendants. Eric Holder is now joining lawsuits in states challenging the ineffectiveness of counsel under state law, which is an amazing first for our U.S. government and has the potential of actually revolutionizing the providing of counsel in all the states, including this one, which highly underpays lawyers paid by the state to represent people in criminal cases. So I would say I hardly call him someone who's holding back. He's also against the mandatory minimums, mandatory sentences.
Oh, the case. Oh. Okay. Oh, good. So you did get an answer. You can ask me afterwards if I still.
I thought the underline was an emphasis.
So you did. I was going to say you should have underlined, but you did. So come on, Brad.
Well, thank you again for attending tonight's event. Let's thank Professor Robinson one more time.
Thank you all very much. It's been a pleasure. Have a good night.